So, good morning. Welcome to knowledge sharing series of Mehta and Mehta. And today's topic is an insight into the charges. Friend, today's our panelist is Mr. Tirupal Godgi, partner Mr. Tirupal Godgi, and associate. Welcome, Mr. Tirupal. He is our frequent panelist and very good friend of us. Everyone knows him and everyone knows his knowledge. To formally introduce Tirupal, he is a FCS, LLB, and BCom graduate and started practice in 2004 after serving as a company secretary of listed and unlisted company. He is also registered insolvency professional with IBBI and is having practice of IBC also. And he was a main core contributor to ICSI Premium on Company Law and regular faculty at various forums like ICSI, ICAI, IOD, and other institutions. Welcome, Mr. Tirupal. Thanks a lot for your time. Today's presenter is Mr. Jai Pansurya. Jai Pansurya is a FCS and Commerce and Law graduate with 7 years experience in the various fields of compliance, corporate law, LODR, IPO, right issue, IPR, etc. He had worked with various types of company, listed, unlisted, private, and he is at present associated with Mehta and Mehta, Vapi branch.
Good morning.
Good morning. We know Mr. Bala, our moderator. And with that, just to say a few words on the topic that charges, we have done it twice or thrice. The topic is old. And after long, again, we are bringing this topic. And I think in recent past, I think it is not touched by any forum on this topic. This topic is a little bit forgotten as it is already understood, well established, people are knowing. But still the company faces the problem in the charges. Especially the company create the charge, satisfy the important thing that they forgot to file the form. The process of satisfaction is left because at the time of creation of charge, bank create and they ensure that it is filed. But while at the satisfaction, bank don't bother. It is company's responsibility. And company do pay with the pain such a big amount and everything, but such a small tail left. And that creates so much problem. And then people, when they want private equity, they want to go SME IPO, main board IPO, and then they see, oh my God. Or they want to raise further fund at that juncture, they realize, oh, this charger, we paid this. How to get it? And they don't have any records of payment and then go to the bank, poor bank, they ask, who will bother bank that they have to check the records 10 years? Friends, it's a big, big thing. So this charge you have to keep in mind. Like I always say, preference shares and charge, you have to keep in mind. When you get a preference share in the balance sheet, remember how many years preference share are old, otherwise you are tendency to remember. The same way charges, whether any modification, whether a reduction in security, please keep in mind. It's a very precious thing. So we have thought that we'll bring that topic again. And Mr. Tirupal is the right person, panelist to be there. So with this, I'll request Mr. Tirupal to say a few words on the topic, then Mr. Bala and Mr. Jai, then you can start your presentation. Over to Tirupal. Thank you.
Yeah, thank you, Mehta and Mehta, Dipti Madam, for inviting me to enhance my knowledge. I'll try to share what I know, but it may not be matured enough to share. I want to learn more from you. Yeah. So this is as Madam said clearly, the charge is in fact after they moved the data to V3 from V2 to V3. Earlier, they were collecting normal PDF document. Now they are collecting lot of data also. So there is a possibility of correlating that data with your balance sheet items also. That is one aspect. Second aspect, there is a time frame that they brought in when they moved to the V3 from V2 to V3. There is an intention behind it, especially the IBC matters. So earlier under the old act, You can go for the condonation of delay with unlimited period of creation or modification that used to be there. So what had happened in the IBC era? People started filing the old dated documents with ROC and then going to the RD for the rectification or the condonation of delay. Due to that, there was a huge, craze that especially whether someone was not as on the date of commencement of CIRP, he was not a technically a charge holder or the secured holder. However, by filing the form with a backdated document, he is getting to a position called secured creditor. So as per section 52, I think in the IBC, the secured creditor position is unique altogether. Like prior to the uh, IBC, Surface was there, security position was separately positioned over there. Taking that secured position, creator's position in IBC also, they give a priority to the secured creator. Now people started, going behind the documentation, finding the old dated documentation and started filing with ROC, ignoring the earlier they must have ignored. Now they want to get themselves positioned to secured creator, including promoters, unscrupulous promoters also they started putting their position into the secured creditor by availing this condonation process. Okay, so that was very crucial. So anyhow, I will share my insight about whenever the situation comes. So let us have the deep discussion, deep dive into this charge chapter. So because it is very, very unique chapter, and see, even you create certain hypothecation, mortgage, lien, or the what is that called, any other type of charge, that is perfectly valid as per the Transfer of Property Act. So valid document is there. You have created, you went to the sub-registrar office and there is a depositor title deeds or even charge registration. Everything is there. And even sub-registrar office is considered to be like constructive notice to the public because anyone can go and obtain the EC of a particular property. But when it comes to the company, there is a one more step ahead. We need to ensure not only just filing the charge with a sub-registrar, like in case of vehicles, you file with the RTA. That hypothecation details you will file, and those will be endorsed in your RTA records as well as your registration, that is the RC certificate of a particular vehicle. But that itself is not sufficient. Companies Act, because it is at the end of the day, it is a company's property. The company's property, the MCA is a public document. MCA website or MCA office is a public place where the constructive notice is considered. And if MCA is not informed, MCA is not kept, updated about the encumbrance of the properties of the company, the MCA says clearly that it is void against the liquidator. Because that special law should be, complied. It's just not that property law that alone should you comply and keep quiet. You can't do it. And it is a responsibility of the creator as well as the responsibility of the charge holder also. Both have responsibility to inform the ROC about the charge created. Okay, so with these 2 points, I will, stop here. Whenever it is needed, I will pitch in and I will share my insights. Thank you very much again. Please proceed.
Yeah, Mr. Bala.
Good morning to all of you. I have a great pleasure in welcoming you all for today's morning session. Let me wish you a happy Raksha Bandhan day to all of you to start with. And as a charge, although it talks section 77 to section 87, although we talk about only 10 sections, intricacies of the sections are too much. Law says many things, but when it comes to the practice, whether it is practicable, law says if the satisfaction of the charge is actually not filed for some reason or other, the person who has actually given the loan, he himself can file the satisfaction of the charge. In reality, nobody is interested in filing. Nobody is interested in doing this. Reality, they are interested in getting the charge filed because they want to secure the loan. But when the charge is over, then it is a difficult thing. Unless you file it, nobody is going to take it, although law provision is there. That is number one. Number two, what happens is ROC is also nowadays left and right. They are actually taking the various issues. And I came across last time, one of the private companies. Last year only it has happened. I think it is Shimoga International Company. It's a ROC has gone into the detail of one of the private companies. So, a private company, the charge is created but not filed. So the company has been penalized 5 lakh rupees penalty for not filing the charges, and the MD has been filed. MD has been actually penalized to that extent. And this is what happened. Even I have come across the late filing, not filing, satisfaction, even modification. All these things, ROC is also looking into all these issues. So there are a lot of intricacies are there. In fact, Tripal has handled a lot of issue because old timer may be knowing. We used to take a loan from the, even today also it is there, I think so. What you call financial insurance bank. They used to appoint the nominee director. The nominee director is holding the office till the loan is actually repaid. The day nominee director stepped down, the loan is already paid. He is already stepped down. We actually record in the minutes. Loan is already paid. The nominee director stepped down. Everything. But we cannot file the charge unless we get the official NOC letter from them. That getting the NOC letter many times becomes a marathon exercise actually. It takes months together, sometimes years together also. So unless we take that, we cannot file it. That is another issue there. And not only that, if you are having a pari passu charges, if you discharge 2-3 banks involved, then what happens? Getting the NOC from each of the bank is again another problem. If we get a NOC from one bank, you can't file the charge, satisfaction of the charge. All these intricacies are there actually, as Dipti puts it. This is the typical issue where practical difficulties are there, and it is there. How do we tackle, how the company secretary is facing the problem, all the things there. I think we will hear more from Tripal on this as we walk along the thing. With this, I'll ask the presentation to be commenced. Over to you, please.
Jay, please start. Thanks. And friends, as usual, please put your questions in the chat box. Of course, chat box is already started popping up with the questions. And at the end, if allowed, time allowed, you are allowed to speak. Okay, over to Jay.
Yes, so good morning, friends. Today's topic is on the charge. The basic introduction I would like to give is that in the realm of corporate governance and in the Companies Act 2013, the charge provision are very crucial regarding to the registration of charge. The meaning of charge means any interest or lien when it is created on any assets or undertaking while taking the finance from any banks or financial institution by the company. Essentially, it's a way for a company to offer its property as a collateral for borrowing money. The need to register the charge is with the ROC. In Companies Act 2013, Section 77 to 87 deals with the charge, where it means security of any loan, where the property is collateral and company becomes the debtor to the bank or financial institution. Charge can be either on a movable property or on the immovable property. Section 2, subsection 16 of the Companies Act 2013 defines charge as any interest or lien created on any property or assets, whether in India or outside India. So these are the topics which we would be likely to be covering today. Chapter 6 talks on the registration of charge. Details is covered under section 77 to 87, and the rules that is company's registration.
Tirupal, have you experienced that charge on the asset overseas and any FEMA implication is there? Your view?
If you own the asset outside India, and then company, especially the case where you have a branches. Anyhow, branches is your own asset balance sheet only. It is not someone's balance sheet, but situation is at abroad only. So as per the FEMA, there is no difficulty in creating the charge. Only the local laws of that particular country where the asset is situated, it should be kept in mind. We need to comply that. As per the FEMA, there is no requirement to get any consent from the RBI, because it's your own balance sheet asset. So RBI is not having anything to say, because you are the owner and you don't need to create any, you are creating someone, because it is a business deal that what we are doing. It's
Right.
part of the business you acquired, and you for the business purpose you are using that.
So, right. And the documents are created in India, so you and filed in India. So
No,
Indian
document
law.
is basically
No,
created in
for filing
India.
purpose. Otherwise, it will
Yeah,
be executed. Again,
yeah.
execution
They will
depends from
create
where
in the
we are
respective
taking.
country. Yeah, madam. They will create at respective country and bring to India for the filing with the ROC.
Yeah. But again, it's again many property, then where the lender is located, all that many, of course, many circumstances and situation is there. But very important point, if the property is located out of country, you have to keep in mind the law of that country where the property is situated also.
Yes,
And
madam.
friends, one thing again, when you send a document out of country for any execution, don't send stamp paper. It is illegal. You have to send plain paper. After execution, bring
And
it
then
in India, and then you do stamping. Okay? Yeah. Jai, go
In,
ahead.
you have to
in,
submit for adjudication within 3 months.
Yeah.
in fact, I came across one of the friend of mine, especially in the overseas charge creation. When they were doing it, everything is okay, as Trupal has said, actually. But what has happened is they insisted, seem to be getting a no objection certificate from the bankers of that overseas company to safeguard the interest. There is no encumbrance. That was actually put up. That's what I heard, actually. I do not know whether it is how far it is on, but they have complied with it. They were asked to get the no objection certificate from their bankers from overseas. Yeah.
Thanks. Yeah, Jay.
So these are the list of sections which covers the charge provision in the Companies Act 2013. So what is the purpose of this charge? Why it is defined in the Companies Act 2013? So basically it covers to maintain the transparency, eliminate the corporate form of frauds, and to inform the ROC, and it is a publicly available document. It provides a public notice of the company's liability and which assets are encumbered, allowing stakeholders and potential lenders to assess the company's financial health. So basically, when the charge is created, the company or the charge holder has to intimate to the ROC with the instrument, and it has to be registered within the time limit. Like from the within 30 days from the creation or modification. If the company fails to register within 30 days, then with the late fees within 60 days, it is to be created. And again, if company or charge holder is failing in 60 days, then there is an additional time of 120 days with a fees of ad valorem duty. Now, suppose if the company or charge holder fails to get it registered the charge within 120 days, then it will be treated as a unsecured. The status will be lost by the secured creditors failing to register the charge.
See,
Now,
that ad valorem duty, that ad valorem duty is very, very big. So, in fact, one of our client case, it had come something like a 5 lakhs filing fees. Can you imagine? 5 lakhs hard. The money we paid it. We are about to reach the 120 days close to that. So we filed the payment and we made the payment also. We have no option. So the ad valorem is very, very crucial here. Should keep in mind. It goes based on the amount of loan that you have taken.
Yeah. And also that beyond 120 days, the implication.
Yeah,
That's
beyond that's what. So you
unsecured.
can't avoid paying that 5 lakhs because to secure the banker as well as the company's interest. So we paid it. So it is better to file within 30 days or next 30 days. Your rate will be just to the any other form. But once you delay, that ad valorem will kill you technically. You may lose even as a company secretary if there is any default from your end or delay from your end.
Yeah, Tirupal, but beyond 120 days. See the
No,
impact.
beyond 130 days senior, it is a con case. Sir. I'm talking about the ad valorem duty within 120 days is very used.
That also, and then though it is unsecured. My goodness. It will be. And
Yeah.
void against creditors and liquidator. This has big impact. Okay. Yeah, Jen. Thanks.
So there was a notification of the Companies Amendment Ordinance 2018. Prior to that, the time
Jai, friends, these questions will run in between. That will keep you awake and also test your knowledge. So you can answer that. It is like a poll. So please, you can go ahead along with the webinar. Yeah, Jay, sorry.
So prior to this notification, means prior to 2018, there was a time limit to get it registered within 300 days by paying the additional fees. So now even in the satisfaction, the time limit is of the 300 days from the new due certificate. The company may file the form for the satisfaction of charge. So these are the types of charges: pledge, mortgage, hypothecation. In pledge, the property is covered like gold, possession of transfer to lender. Mortgage, it is covered immovable property like building, where ownership rights are secured. Hypothecation, where assets like car, uh, stock, book debts are created as an instrument. Even few companies are creating a cross mortgage charges, wherein two properties are involved. So again, there is a fixed charge and flexible charge, wherein a fixed charge, the land building is covered, and in flexible charge, the assets or raw material, as I said, it is covered. In fixed charge, the lender has a low risk, cannot dispose his assets, and in flexible charge, the more risky for lenders and can use assets in business. And flexible charge can also be converted into the fixed charge. Crystallization of charge, conversion of flexible to fixed, and when it can be created. Like to convert the flexible to fixed, deed has to be executed, and only it can be done at the creditor's discretion. When the company is into liquidation or a company has ceased its business, then only it can be converted from flexible to fixed. Section 77 talks on the registration of charge. Like it's a duty of every company to create a charge, whether its property is situated in India or outside, tangible or intangible, and it has to be created within 30 days from its creation. Now, there are two forms to be filed with the ROC. If the charge is created other than debentures, then CSG 1, and if it's a case of debentures, then CSG 9.
Yeah, here I would like to throw some light as per the CSG1 and CSG9. See, like suppose holding company is receiving NCD, but the holding company NCD in holding company also gives its assets and subsidiary also gives its assets. As far as the holding company is concerned, since it is issuing the debenture, it should file the CSG9. And as far as the subsidiary is concerned, it is giving mere its assets as a security for the debenture issued by the holding company. So subsidiary cannot file the CGH9. However, many cases the banker or the debenture holders are insisting even to subsidiary to file the CSG9, which is not correct. CSG1 should be filed by the person who is giving the security. Whereas the debenture, wherever which company issues, that company has to file a CSG9. So this is the lot of confusion is there.
Yeah, very valid point, develop. Thanks.
In fact, as you rightly say, people insist for CHA 9 actually from banker side.
Yeah, banker doesn't know that, but see the only document in the charge chapter which will connect it to the type of loan. This is the only CSG9. No other, document or the any other like say 77 says any creation of charge on the assets or property. For what purpose? It doesn't say. It may be of your own loan, it may be of someone's loan, doesn't say. It doesn't, could be anyone's loan. The idea of 77 is whenever there is an encumbrance on the assets of the company, that should be informed to the public. So for that, they have not given connection. Whether you have drawn the loan, someone has given the loan, someone has taken the loan, you have given the property, it is immaterial. But you should say my property is encompassed.
Yeah.
Whereas the CSG9 is you should say it is my loan, in the form of debenture, and it is my asset. Both should be of yours only. That is the difference between normal charge and the debenture.
Right. Thank you. Thank you for inputs. Yeah, Jay.
So this is the basic summary. Like when the charge is created and once the CSG1 or CSG9 form is filed, the ROC will issue a certificate of registration in form number CSG2. When there is a modification of charge, the ROC will issue a certificate of registration in form number CSG3. This certificate, whether in CSG2 or 3, it is the conclusive evidence required under Chapter 6 of the Act. Subsection 3 of this Act state that notwithstanding anything contained in any other law for the time being in force, no charges created by a company shall be taken into account by the liquidator or any other creditor unless it is duly registered and a certificate of registration of charge is been issued. So if a company fails to register within a prescribed time limit, then it won't be treated as a secured charge when the company is account into the liquidation. Section 78 talks on the charge registration by a charge holder. Like if a company fails to register its charge under Section 77, then the charge holder may file CSG1 by giving a 14 days prior notice to the company for filing the form. And within 14 days, if company doesn't file the form, then the charge holder may file the CSG1 and the expenses incurred by the charge holder shall be reimbursed by the company. So, if company fails to register its charge or satisfaction within the prescribed time limit, then with effect to 1st April 2021, there was an amendment in Schedule 3 that it has to be mentioned the reason and detail why the charge or satisfaction of charge was not filed in its financial statement.
Yeah, this is basically to disclose to the public, especially whoever is going through the financial statement, because tomorrow if this company goes per the IBC and company itself has disclosed clearly the charge was created on the asset of XYZ, but however the same was not informed to the ROC within the time frame. So it is very apparent. Tomorrow, you can't go and manipulate the records. No, it is very apparent that you have already given, and the charge holder also is aware of it. So they are well aware that is a if the company goes for liquidation, that fellow will become an unsecured creditor. But of course, during the liquidation, during the CIRP or before the CIRP, that fellow will continue to be a secured creditor. Because the section 77 says clearly during the liquidation, either under Companies Act or under the IBC, that creditor will become unsecured creditor. But it doesn't say during the lifetime of the company. So during the lifetime of the company, he is a secured creditor. He can enforce the law by the common law. For enforcing his security, he doesn't need to go to the IBC provisions. He can enforce through the common law because based on the Transfer of Property Act. He has a document with him, registered mortgage deed is there. He can certainly go and enforce it. Only liquidator can deny it. But liquidator comes only at the back end. So during the lifetime, as per my understanding, that man will continue to be security holder only, not unsecured creditor. There is no requirement you should classify that the gentleman is unsecured creditor in your balance sheet.
But Tirupal, the provision was telling that it will be, unsecured creditor for
Nowhere is written. Let me.
120
madam,
days.
see,
After 120 days.
No, it doesn't say unsecured creditor.
Okay, meanwhile, we will carry on this presentation.
See, if it written subsection 3 of 77, notwithstanding anything contained any other law for the time being in force, no charge created by the company shall be taken into account by the liquidator. But liquidator comes only the frag end.
Yeah, liquidator. But even creditor, what 120 days Jai, take through that slide, no, that 120 days more charging filing more than that. Late
See, it
filing.
is written unless other creditor, see, secured creditor or any other creditor, unless it is duly registered and subsection certificate is written. So there is a concept of other creditor may deny it. But if suppose there is no other creditor in this company, you can enforce it.
Because beyond 120 days, void against creditor and liquidator. Liquidator very clear. So
Liquidator is very
it
credible.
says void against creditors.
Hmm.
That is the point.
So subsection, madam, subsection 4 also says nothing in subsection 3 shall prejudice any contract or obligation for the repayment of any money secured by a charge. Even yesterday, Bala sir was telling same way. So the payment will continue to be there. Now the fight is about the secured or unsecured. But if there are no other creditors, but other creditor to claim,
Yeah.
it should have been in his favor.
Yeah,
Suppose
yeah,
no
you
one
are
has
right.
created.
Yeah, it is unsecured, secured. They will take the position of unsecured because it is void against creditor for any time after.
One problem might come. Suppose for the same property, you take a loan from somebody equivalent to some 25% of the loan which you are not registered. And again, the same property, you take another 25% of the loan from the one more bank. Now that charge you get created. Then what will happen in this situation? The person who is holding the charge created, he will object to this person's. And his priority will run as a secured creditor. Once his charges are repaid, then only this fellow can enforce it. That question will actually come. That is what I think Tirupal is actually telling.
That's
there are no other creditors.
Anyhow, it is very niche area based on the facts of each case will vary.
Yeah, correct.
Yeah.
Because normally it happens. Because normally what happens, large assets are given as a security to one banker, but again they go to the other banker, they use the same property. Or sometimes it happens the pari passu charges. But in such a case, what happens is this sort of a problem will arise. Yeah.
Right. Yeah, Jay, go ahead. Go to your slide. Sorry.
So section 79 talks on the section 77 applies to in certain matters, like company acquiring any property subject to a charge or any modification in terms or condition to the extent or operation of a charge registered under that section, then automatically section 77 will be applied. Section 80, date of notice of charge. Like what will be the effect? It will be a deemed notice to the entire world, constructive notice, and the effect of non-registration will be valid for company and void for the charge holder or bank. We discussed in the previous slide, it will be termed as an unsecured status. Section 781 talks on the register of charge to be kept at the register office of the company. Need to be read with Rule 7. Register of charge to be kept by the ROC, which is maintained on the MCA website under heading Index of Charge. Section 82, company to report satisfaction of charge. Like satisfaction of charge when the tenure of financial assistance has been expired or the instrument is revoked by the parties and or the expiry has been with the mutual consent. In that case, the satisfaction of, or the payment of charge has been paid by the company. Section 82 read with Rule 8. The company shall give intimation to the ROC in form number CSG4 within a period of 30 days from the date of such payment or satisfaction. Where the satisfaction of the charge is not filed within 30 days, then within 300 days, the company can file it with the payment of additional fees. Register to send a notice to the holder of charge before registration the satisfaction. If the intimation to register is signed by the holder of charge, no notice to be sent by the ROC. As per Rule 8, the register the satisfaction and ROC will give certificate under form CSG5. This is a basic summary, like company will file the satisfaction in CSG4 and the time limit 300 days and additional 270 days. And beyond 300 days, it has to file CHG 8 for the condonation of delay with the central government.
Yeah, condonation of delay will be a separate process. You have to make a application to the central government. I think the CG1, you have to give the justification, etc. Then the condonation might happen. That is a separate process. You have to initiative. You have to go to the central government, which is situated at Delhi. Actually. Yeah.
See that no, the central government, they have delegated power to the regional director. So the regional director, once you file this form, CHG 8. So what happens? So whenever there is a delay in filing CHG 4, after filing your form, you will get a dialog box. The form is not taken on record because it is filed beyond 300 days. Kindly file the CHG 8 like that, you will get dialog box.
Okay.
And once we file the CHG 8 itself is an application for condonation of delay. You can enclose all the details as well as your justification for delay, everything, and it will be dynamically routed to the regional director concerned. Okay, the regional director concerned will approve. Earlier they were calling for hearings and all. Now they are not calling for the hearings. They will approve if they are satisfied with the explanation that you have provided in the form. And while approving, they are giving certain penalties. So you have to pay that penalty. Unless you pay that penalty, you will not get a condonation order. After getting condonation order, we are supposed to file one form called INC 28. And in that, you will connect the CHG 4 form SRN and this CHG 8 SRN also will be connected. Upon approval of the INC 28, your CHG 4, which was waiting for the condonation order, will also get automatically approved by the system. So penalty should be paid. They are levying some 25,000-30,000 penalty is levied, and you have to pay for that. Then file INC 28. Then system will approve the form.
By and large, the condonation will get approved, or there will be a rejection also?
No, they generally approve it. This is only satisfaction. No, it is not that someone's right is affected. Third party right is not affected. It is some due to technical reason in getting the NOC from the concerned banker got delayed. So that is the reason. So they are, by and large, they are approving this CSGA force by our regional director offices.
So only thing is penalty is to be paid.
Yeah. So if you don't pay the penalty, you will not get the order first. It is a technical again. So that order will come only after making the payment. After making the payment, you have to file that form INC 28. That order it all will be coming through mail only. So wherever that form CHG 8 is there, no, you have filed in that is a V3 version. There you will get the details about the order and payment. Everything you should do that. Then you will get order. Then you can file INC 28. Technical completely.
Yeah. Okay. Yeah, Jay.
So section 83 talks on the power of registrar to make entries of satisfaction and release in absence of intimation from the company. Like when there is no intimation from the company's end, registrar has a power to remove the charge created under section 83. Power of ROC to make entries of satisfaction and release. ROC can suo motu if satisfaction they are known or they are having any knowledge, and ROC will inform to the affected parties within 30 days.
Tirupal, you have walked this way?
Here, that
Can
you
you
go back to this.
Yeah.
Yeah, madam. Please. See
Raise-
here,
Yeah.
the suo motu satisfaction registration by the ROC, in general, they are not doing. But if you are able to, as a company, and has information, like we have done one case, it was around 15 years old charge, and we got the kind of satisfaction letter dated 15 years ago. Now we were trying to file the form SH4, the CH4, and the banker was not ready to sign because the current staff in the bank, they say we don't have any file, we cannot file it. We can't affix the digital signature. So then we bring this particular thing to the ROC knowledge. And we requested ROC. What ROC did that he has issued 30 days notice to the banker. And the banker Some bankers have responded saying that as per our books, there are no charges, subsisting. That can be given. No banker may not be, you can give that letter because the ROC is authority. So they cannot keep quiet also. If something is there, they should write to them. So in one of my client case, they said, yes, we don't have any, pending loans against any property against this company. Like that, they have written. So based on that, ROC to charge, remove the charge from the register. Next one is about the case where banker has written. So I am waiting for the NOC of other consortium leaders. That is the reason I am not signing this particular form. So now we are going behind the consultant leader who are ceased to be consultant leader around 10-15 years ago. So we are unable to, even ROC is unable to pursue that matter. So the satisfaction, if you got evidence, no, there is a possibility ROC will take a suo survey notice on the respective banker or the financial institution and wait for the same thing, wait at 1 month, 30 days. And then if there is no response, they may remove the charge also. If there is a response, they will go based on the response. In fact, in one of my client case, what has happened, that when you go for some limits, no, they will ensure that, especially for the working capital limits, whether there is a property or not, simply they will create hypothecation, present and future. And they will ensure you to file the form. The company has filed that particular form in the old system in 2012. And that charge was created for around 22 crores on the working capital limit purpose. Subsequently, the bank has discontinued the fund, what is that called, working capital facility. They given one letter saying that we don't want to provide a working capital facility. That's not only one letter. They have not given any loan. Only one sanction letter was there. They made a company to sign one hypothecation deed for the future working capital assets, and they made to file the form. And after that, next day they have released one letter saying that we don't want to extend this limit. And charge was created, company also kept quiet, banker also kept quiet, and we were filing the, sir, I think told no, we filed for the not IPO, it is a consolidation. We were filing around 5 companies merger.
Oh,
ROC staff and RD staff went to the master data. They found there is a 22 crores. Then we are given all the, from 2012 to till date, all balance sheets we are given. Sir, they have not drawn that limit.
arre baap.
My merger was stuck.
Oh my goodness. The same thing, this way our experience, this charge has created such a big problem when you take big corporate action. So it
Then
is
we went to that bank, that banker, we earlier in some place was there. They moved that branch and met with some other branch. They have no record. No banker is ready to support, no manager is ready to support. Then finally we approached the ombudsman. We have shown that earlier withdrawal letter also. Then finally, ombudsman made the banker to give an NOC with current dated. Based on that, we showed to the master data and we filed SS4, CSG4 and given to the NCLT that the charge is satisfied. ROC told very clearly, charge is there. You get the NOC from that 22 crore fellow. NOC purpose is asking.
Oh my God.
Otherwise, he is asking, convene a board creditors meeting.
Oh,
Marathon exercise, huh? Marathon exercise.
baapre.
How creditor
Tripal.
meeting convened when there is no creditor at all.
Yeah.
At 0 debt company it was.
One mistake. Oh, thanks a
Yeah.
lot for sharing such an experience. Wonderful. It was
Yes.
pleasure. Thank you.
So satisfaction, this particular section will help us, but
Yeah.
it's better to have good, quick, understanding with ROC, what they want data, and all. You just go ahead. We have provided all balance sheets and earlier sanction letter, subsequent withdrawal letter, everything we have provided. And they say that, yes, maybe, then in turn they have submitted report to the NCLT. There is no loan. However, the charge is existing. We direct the company to file a satisfaction. And based on that, they have finally given the NCLT order.
Okay. Thank you.
Yeah,
Thank you,
because
sir.
one thing is very clear, the Tripal. Getting the NOC letter after the loan is repaid is
My
actually a
God.
big exercise from the people.
Yeah,
Because that generally doesn't happen. In fact,
Correct, sir.
I think company secretary should say the director who is actually resigning from the board, get me the NOC certificate and then submit the resignation.
Well, I will tell you the cases where the immovable property is involved, the bank will be or the company will be more keen on the getting the documents released. And you will get some document evidence is there to file the form. The cases where you have hypothecation of like a book debt or hypothecation of fixed assets, hypothecation of working capital asset, where you don't need to get relieved any document from the banker. So that is the challenge. So bank also will not be worried about, and the company also is not worried about to get any letter for full and final satisfaction letter.
Right.
They will move quickly, and other bank also will not insist any document to be produced or NOC from the existing bank. Other bank will provide the sanction limit based on the future hypothecation of its working capital assets.
Right. Okay. Jay, go ahead.
So rule 3, sub-rule 4 talks on the verification of instrument. If the property is in India, then from the company side, either director or company secretary, and from the banker side, any authorized officers. If the property is outside India, then from the company side, with the common seal, either director or CS or any other authorized person by the board. And from the banker side, any authorized officer or other person. Rule 84 talks on the intimation of appointment of receiver or manager. Section 84 read with Rule 9 provides that if any person obtains an order for the appointment of a receiver or of a person to manage the property, he shall within period of 30 days from the passing of such order making the appointment give notice to the company. The notice of appointment or cessation of a receiver or a person who manages the property subject to charge shall be filed with the ROC in form number CHG 6. Section 85 read with Rule 10 company's register of charge. So every company who is creating its charge has to maintain a register in form number CHG 7, and it has to be kept at the registered office. Entries such as creation, modification, or satisfaction has to be made in the CHG 7, and it has to be authenticated by a director or a CS or any other person authorized by the board. The company may keep open for inspection the register of charge. The inspection can be done by a member or creditor without paying any fees, or any other person. If they want to inspect, then a fees has to be paid. The register of charge has to be preserved permanently, and the instrument creating a charge or modification shall be preserved for a period of 8 years from the date of satisfaction of the charge. Now, Section 86 talks on the punishment for the contravention. Like if a company is in default in complying the provision of any of the section like 77 to 85, then a penalty of rupees 5 lakh has to be paid, shall be levied, and every officer a penalty of 50,000 rupees. If a person is willfully defaulting or has furnished any false or incorrect information, either knowingly or any surprise any material information, then he shall be liable for action under section 447 of the Companies Act.
See here that default, if you see the default, like example, one of the, one Mr. Ravi is asking what is the situation after expiry of 120 days of the creation of charge. This is the one of the consequence also. See 86, even for those cases where you have not filed the form within 120 days time, the ROC may insist to go for adjudication, wherein the penalty would be minimum of 5 lakhs on the company. She simply 120 days have not filed the form. One way the creditor may become unsecured creditor, that is altogether different. But as per the company is concerned, I think there are certain adjudication orders. She knowingly that based on your data at the balance sheet, You yourself, you are committing the suicide. Like you are supposed to make a disclosure about non-filing of forms within 120 days time, and you are providing information to the ROC. So ROC can take a call saying that you have violated the provisions of this particular chapter. So I will adjudicate you. The minimum penalty, look at this, is a 5 lakhs, and it is not up to also. The word directly 5 lakhs is there.
Yeah, that
Next
is right.
one
5 lakh rupees is the amount.
5 lakhs is the amount that they will levy, they are levying also. Similarly, for the officer in default is 50,000.
Correct.
Similarly, this way, you have a section 134, which speaks about, and 128 also, which speaks about the financial disclosure of the financial statement. Assume that you have not made a disclosure that is needed on the other regulatory disclosure or para number 12, I think, Roman 12, where the charge details, whether you have filed within 120 days or not, and 129 violation will come. And there you have a 3 lakhs penalty, something comes here for the company. And officer is 50,000. So the consequence for non-filing the ING 28 directly many are the company, indirectly on the secured creditors. So very
Not,
crucial this particular document, very crucial this document.
not only that, I have actually come across in one of the ROC order of Gujarat. I think if I remember correctly, it was some company called Steel Connect or something like that. In that company, what they have done is they have actually levied the penalty on the insolvency professional and also ex-liquidator to failing to file the charges. That is what it has happened. Because what has happened is the board has been taken over by these people. They are going to pay the charges. So they have been levied penalty actually. It's a Gujarat order is there actually. Yeah. Yes, go ahead.
So element of fraud is there. Again, element of fraud is there. 447 it will become. So mens rea, all those things they will look into. If there are no mens rea, okay, you are saved with 5 lakhs. If there is a mens rea, then it goes to 447.
Right.
Section 87 talks on the ratification by the central government in the register of charge. Like if the central government has been satisfied that the omission or any misstatement was accidentally or any inadvertence, and it is not prejudiced to the position of the creditor or shareholders in adverse effect, then the central government may direct to ratify such omission or misstatement. For ratification with the central government, the company has to file Form CSG 8.
Yeah, this is basically for creation modification, the documents which you have filed with the ROC have some errors. There it comes, this particular provision comes there. You have filed, there is some like tenure error is there, or some, creation, some data, some missing is there in your document that is already registered, that you want rectified. It is not that, I have not filed within the time. That is not error first year. So only those errors which already accidentally something happened while filing the earlier forms, those can be rectified by filing the CH8. And similarly, CH8 we just now explained, for that next radio button at CH8 is for the satisfaction delays. So total 2 radio buttons will be there in the CH8. One for the already registered creation and modification related document, and if there are any errors in that, to rectify that, you can file it. Next one, delay in filing the satisfaction. Yeah,
Yeah.
go ahead.
So these are the forms which are covered under section 77 to 87. Like CSG1, it is for intimation for creation or modification. CSG2 is ROC will issue the registration certificate. CSG3 modification certificate. CSG4 for the satisfaction of charge. CSG5 is for the certificate on the registration satisfaction of charge. 6 for the appointment of receiver or cessation of any receiver or manager. CHG 7 for registration of charge or company's register. CHG is 8 for condonation or any satisfaction beyond the 300 days. And CHG 9 is for creation or modification for debt security or debentures. Now, these are few of the FAQs. Like, what if there is any omission or misstatement of any particulars in any filing made by ROC? Then we need to apply to the central government for the such ratification or omission under section 87. Treatment of secured loan when a partnership firm converts to a company and filing of CHG 1. Now, here there are few stepwise process, like the company need to execute a novation agreement, which means that now all the liability will be transferred from partnership firm to the company. And or upon execution of novation agreement, the charge has to be filed with ROC within 30 days in either form CHG 1. Again, if there is a non-compliance of filing CHG 1, then in section 77, subsection 3, the liquidator will be treating such charge as unsecured creditors. Few of the case law under Companies Act. That first is Indian Bank versus Official Liquidator, Madras, wherein whether an unregistered charge is enforceable against the liquidator. The answer was an unregistered is void against the liquidator and creditors under section 125 of 1956 and 77 of 2013 Act. The lender lost the priority rights if the charge is not registered. Second was Karnataka State Financial Corporation versus Official Liquidator, wherein the issue was the priority of charges when multiple creditors exist. First in time registration gets priority. First charge holder ranks above subsequent one. Failure to register again, it lost the priority. Third case was Axis Bank Limited versus Sirpur Paper Mills Limited, where the issue was whether a charge created by a court order needs registration. The answer was court order charges under the Sarfasi Act must still be registered under the Companies Act. No registration makes them enforceable against the third party. Fourth case was Official Liquidator versus Suryakant Natwarlal Surti, where the issue was does a court decree passed in favor of a lender based on the unregistered charge before winding up of charge. The legal position regarding enforceability. It was held that no, the decree does not override the requirement of charge registration. Even if a lender obtains a decree court order for recovery based on the unregistered charge, the charge still remains void against the liquidator and other creditors once the company goes under the liquidation. Fifth is does filing CHG 1 after CIRP, but within 30 days of charge creation, make the lender secured. This was for the NCLT view held in the Bank of Baroda versus Raj Oil Mills Limited. The reason is CRP frees the company's assets and post CRP filing cannot alter the creditor's right. Second was with Kotak Mahindra Bank versus HNIL. It was held that even if CHG 1 is filed within 30 days, if CRP begins before registration, the charge is void against the RP, that is registered professional. Punjab National Bank versus Mittal Corporation. It was held that the cutoff date of secured status is the CRFP commencement date, not the charge creation date. So, with this, we would like to conclude that the charge under Companies Act 2013 is essential for the companies and their officer to ensure a proper compliance and avoid the penalties. The legal framework is for the registration of charge and safeguarding the interest of stakeholder and upholding the corporate transparency.
In fact, the charge and search report is one of the very good area for the practice to our profession.
Yeah.
In fact, nowadays, lot many banks who are lending the money, they are more interested in reading the search report and knowing the things, etc. and other thing and all. In fact, there are a lot of company secretaries who are doing this actually, full time only. That is the thing, is one of the good area, although it is a small topic is there. Let us go into the questions. What are the questions are there?
Thank you, Jai. Thanks.
Thank you, everyone.
Yeah.
Do we need to register the charges for the loans against fixed deposits?
Yes.
See, if you look at the 77, it says clearly two words they are used: asset or property. Now tell me whether the FD, fixed deposit, is not a property or asset in the balance sheet of the company. Simple. If you are able to answer this question, then you got answer.
Yeah. You're right. Even whether tangible or otherwise, you have to register.
Correct.
Yeah, it says it is the duty, it shall be the duty of every company creating a charge. So it is creating a charge. Now tell me, what is a charge is defined. I think it is defined as a lien. And lien is defined. It says clearly you are creating encumbrance over the assets of the company. And generally in the fixed deposit, you will create on the lien. Behind the fixed deposit receipt, they will write it. This is lien to the bank for paying the this. And even for the online fixed deposit receipt also, they will create a lien. So lien is nothing but a charge. So when you create a charge within or outside India on its property, now tell me, or the asset, now tell me whether this fixed asset is not an asset of the company. So it is an asset of the company. So you have no option. Earlier, the problem with the understanding of this particular chapter, if you look at 125, they have described I'm talking of 1956 Act. They have described around 7 or 8 type of charges which are registrable. Now in the new Act 77, they removed that particular concept of description. They simply, wrote in the 77 clearly property or asset, whether tangible or intangible, whether in India or outside India. So in the balance sheet, every item will fall either of these, either it call as a property or call as asset. So for fixed deposit, if you create any charge on that particular instrument, one should file the charge with the ROC, otherwise it will be violation. And we saw what is the violation, like what is the 120 days violation, then reporting at your own balance sheet. The next one, 86, there is a penal provision, again fraud, all those things will come into picture. So one should file, you should ensure whom you are giving this fixed deposit. Generally, I'll tell you what my understanding or my knowledge about this fixed deposit is basically to provide a BG, a bank guarantee. The banks will insist 100% security by way of a fixed deposit. So then, based on your fixed deposit, they will sanction the BG limits to you. Technically, you have money with you, but some reasons, like example, you want to procure some order from some of the government department. Government department says, I will give the order, but provided you give a performance guarantee or give the some guarantee from bank with this amount, I will sanction you. I will also sanction or release some advance for it. Now, without bank guarantee, you cannot perform your job. You can't do your job as a company. Company cannot proceed. Now, invariably, you should go to the bank and get the BG. In fact, I have a company wherein the company is a cash-rich company. Always in the company balance sheet, you will find minimum 50 crores in the FDs. And the company doesn't need to borrow any money. But despite of that, the company's balance sheet, if you find, you will get at least 15, 16 crores borrowings are there by way of only BGs. For BG, I need to create a FD. So in this 50 crores, I have created FD worth of 10, 12 crore. And I've got the BG. BG is a part of business. Without BG, I cannot proceed, rendering services to, especially to the government departments. So we fight. In all the cases, fixed deposit charge given to the other bank was filed, and bank also agreed and filed. But some banks are there, like kind of ICSA bank, their executives are not well versed with this, so they don't insist either for fixed deposit, even for the vehicles. Vehicle is the one challenge what we are facing. No one is ready to create a charge because that particular force is there. No, that vehicle sanctioning team in the particular bank, is a private company. They have outsourced it, so they are not aware of it. Their idea is only just get the document signed. They in fact get the document like hypothecation is signed, and the chassis number and the particular vehicle number is already written in the hypothecation deed. Still, they will not give the hypothecation deed to the secretary department for uploading. This is the challenge.
You have very nicely explained, actually. You asked a very fundamental question. Is it the asset or it is not an asset? That's the thing. That gives the answer. Okay.
Yeah, next. We
In the memorandum of the deposit of the deeds, what is the date creation of the charge? Either date actual deposit is 2/8/25, date of execution of the evidencing the deposit of the deed is 4/8/25, date of stamping of the registration 5/8/25, date of updating the loan details CRESI 8/8/25. So what is the date he is asking?
Yeah, this is simple here. What we need to understand, the name, that particular mode of mortgage, deposit of title deeds. When I have deposited technically with a bank, by creating what is that called English charge. It is called English charge, or I can say pari passu charge, or I can say it is simple mortgage. Okay, this charge you are creating moment you deposit the money. Deposit the titles of your property with the banker. The banker secures from that moment the subsequent evidencing letter dated, or nowadays most of the banks, this particular state government, they want revenue. Earlier, this deposit title deed was not a taxable event. Once we were not paying any stamp duty for that. However, now it is a routine. Instead of going for registered mortgage, we used to go for deposit title deeds, and there was never been a stamp duty. Now, in almost all states, they have included in the one of the item chargeable items. So they are collecting, but not the amount equivalent to the registered amount. They will collect some 2%, 3%, subject to a maximum of 10 lakhs, like that it is there. So for enforcement, the stamp duty sometimes will be paid little late. So that date of stamp duty is not the date when you actually pay the stamp duty. That is not a date when you created or evidence. It is the day when you deposit is the day the charge is created, not the day when you write the letter, not the day when you pay the stamp duty. And if you see that particular execution of the document evidencing the deposit title, you will come to know that when it was deposited. See, it is basically depositor title deeds. The company person is supposed to carry the original document, visit the particular premises of the bank and hand over those documents, and then write, I am authorized to deposit this particular XYZ document because company has borrowed this money and we are creating a mortgage by way of depositing title deeds with you. Hold this document further till the repayment. Hold this document. He will give the list of documents in that particular list. So then banker will take that evidence letter signed by this particular gentleman from the company end along with the board resolution and record in their book called memorandum of title deeds. In that book, they will make an entry. So you will get another date also, one more date also. Now you may ask me so many questions like when it is actually created charge. So actual creation of date, the moment you hand over the original document with the bank is the date of creation, not any other dates. This is my understanding, my practical exposure.
Right. Thank you. Yeah, next.
Okay. In memorandum of entry, recording of the oral assent, there is no instrument of such executed, and then what is the document to be attached with the form CH1 for creation of the charge?
See, the company, I don't think company will go have a oral contract. As a
Right.
company, you have a contract, written contract. What is that oral contract this gentleman is trying to tell? I'm failed to understand. What kind of oral contract can be created by way of a charge creation? So one I understood is the one pledge of the document. Pledge of the document or pledge of an article. You just go and add. But there also you can certainly have a document. I will tell you the problem. The person who is taking that particular asset or property without a document, tomorrow you yourself can go and file a case against him saying that it's a theft. Correct? No, stolen document it is. So
Yeah.
no person can accept the document orally.
Right. Next.
At present, creation of the modification of the charge used to be filed within 120 days. What is the way out available if the same is to be filed beyond 120 days?
No, you can't file first day. You can't file.
You can't file
Okay.
it.
Next course
But-
of action is available. You should go and approach. In fact, recently we had 2-3 situations. They want to file it. So what we did, we have executed yet another hypothecation deed, giving effect only the current date. I told you from the old date to till date you will be an unsecured creditor, but execute another document. See, there is no connection from the date of borrowing and date of creation. You can borrow an unsecured loan, and creation could be any time subsequent to the during the loan subsist. It can be any date. So initially you have created one document, and that document could not be informed to the ROC within 120 days. So that is has no validity in terms of the ROC. However, you create another document today. But there is a challenge in this. You must have paid the stamp duty at that particular point of time, and that stamp duty again you need to pay while creating the new thing. So the loss to the company is to pay stamp duty again, apart from executing the fresh document. Once you execute the fresh document, you will be able to file the form again. That means file the form, the new form freshly now with the new execution. That is the one course of action that is available, and we are suggesting all the cases. Okay, there was a default for some the time being, but somewhere you should rectify. You can't keep, suppose there is a loan like a term loan is there. Term loan will be for the 10 years. All the 10 years you can't be defaulter. Instead, you be a defaulter for 3 months or 4 months or 5 months. Subsequently, you rectify it.
So in that agreement, you will refer to your earlier agreement and you say it is in further to, or that agreement is since it is
So you
contract,
can
you clarify in this agreement, right?
Yes, madam. The first one is, though you refer or not, anyhow, it has no validity as far as ROC is concerned. It is a kind of modification. So you are filing freshly the modification as if it is a original.
Yeah, because no, but in the sense when there is a due diligence and if you have both the documents, it will have an
No,
issue.
violated.
You have to
See.
clarify and in that your subsequent agreement, right?
Yes, madam. You have violated. First instance, you have violated. Second instance, onwards, you are trying to board the train. That's all.
Okay. Yeah, next.
When a charge is to be created, modified, at the filing of the form beyond 120 days, can we actually section 460 condemnation of delay and then the file of form CHE1? Please share your experience in handling such assessments.
Yeah, see, if you look at the 460 section, it starts with notwithstanding anything contain any provisions of this act. In fact, that 460 is the absolute power given to the central government, that is headquarters, to condone. One is an application to be filed like various sections like a managing director appointment, all those things. Another one, document, subsection B says documents to be filed with ROC are delayed. So they have absolute power to condone any document is to be filed. In that, charge is not a exception. But however, as per my understanding, that MCA at Delhi level or any other level, they are not approving the charge document. If anyone wants to file, let them file the CG1. That is the form that you are supposed to file. File the CG1. Try to explain your situation. See that because MCA is not prohibited from condonation of the delay. It is over and above the condonation that is available under charge chapter. Charge chapter condonation is now limited to the only satisfaction. However, this particular 460 subsection B, he empowers the central government to condone any document delay, but it is a pure discretion power of the central government. I don't think they are exercising, and we have not explored this option. Yes, you can try. If you get any inputs, please let us know.
In case of the mortgage loan amount fully paid on 31/1/25, but bank released the mortgage documents only on 6/8/25, which date is to be taken for the satisfaction of the charge?
See, technically, if you see the full and final settlement, there's a concept of full and final settlement. So as per as the books of the company, you would have paid some money. But there may be some other charges the bank before releasing, like document handling charges would be there before they release the document from their trust. So they may charge 100, 200 rupees. There are cases are there. So before releasing the actual document, they may collect more over and above the loan amount, some amount. In few of the cases, what we found is they are taking some 100, 200 rupees like document handling charges, and they are releasing the deed on the 8/8/2025, not as on the 31st January 2025. So it is not mere payment alone. Ultimately, company is supposed to get the documents back that are, hypothecated or pledged or mortgaged with the lender. So you should ensure, along with this particular release, let the bankers clearly state till today there were no, or as on today there are no liabilities. I am releasing the document today like that. But if they connect, saying in the releasing letters clearly on 31st January 2025 the loan was fully repaid, we have verified from our records, and now only we are releasing the document, and take the document. And if they have mentioned current date, referring the old payment date, then you are gone. You have to file the charge only from the 31st January 2025, not today's date. It is how you will manage with the banker, it matters.
Right.
In many companies, very old charges are shown as outstanding on the MCA portal, though the underlying loans were actually closed long ago. Now
Right.
banks are actually obstacle in providing no due certificate for filing the satisfaction of the charges to this. Yeah,
We
this is what
discussed it, what I think
Tirupal was actually telling. Yeah.
we all discussed in starting only I mentioned you have to now tell bankers, otherwise it's not
I
that.
tell you, see what has happened. See, they have migrated data in the year 2006. They just gone to the old system of MCA and just migrated data in 2006 when they moved the system into the MCA. So those times, certain charges, especially those where Form 17 was there for satisfaction. Form 17s were already filed, registered, but not put in the system. Not means put in the D file or somewhere else. Those cases, we have recent challenge of this. Satisfaction was there, and we got the certificate of satisfaction, and 17 were registered, and we have copy with us. Still, the charge that the MCA system shows is not satisfied. So that case, when we produce the 17 form with the ROC, they have removed the charge. You can get released if you got evidence of payment and evidence of filing Form 17 under the old system. They are doing it.
In rest of the
The
secured,
only no due certificate alone is maybe difficult to get it. If you have got everything with you, including even you are not filed in the old form, today you can file it with a delay and you can go for a condonation.
in respect to the secured loans fully repaid, if the charge is not actually satisfied by the filing CHC4, banks do not cooperate the documents and oral. Can we not actually request ROC to rectify under this section 83?
Yeah, this I have explained you clearly. I think Karthik Vardarajan sir has asked this question. So this, what I'm just trying to, we have approached recently few cases. The ROC has invoked this 83, and they have served the notice to the charge holder and seeking their objection and say that we want to remove these charges. We found satisfactory evidence from the company that the charges were already repaid and there is no asset secured in your favor. So please kindly, if you don't do that, or means if you don't object, we are going to remove. So they are writing one letter with 30 days notice to the particular charge holder, and the charge holder, if he doesn't respond, they are going ahead and removing those charges. You can explore this.
We took the bank loan of 150 crores and the CH1 is in place. Afterwards, same bank granted 125 crores next year. Without satisfaction, can we actually create another CHC1 this year? It will impact rating.
Yeah.
If you are
See
not
here,
that,
look
yeah,
at this 120, 50, whatever it is. Is it a working capital loan? Is it a separate term loan? What happened to 150 crore? Have you repaid that? These questions are not there. These are not answered. Suppose if it is a 150 crore was a working capital limit earlier, and you have filed CSG1 showing it is a working capital limit, and in the subsequent year, this working capital limit is reduced from 150 to 125, and then you are supposed to file a satisfaction, not the creation. One more creation is not required. You have to file only
modification.
only modification, and no need to file a satisfaction for the 150 crore. So I think in my one of my client case, I think the Bala sir was telling the charge is a good practice, and search reports is another good practice. And now, of course, added to that, you have a bank due diligence, then some certifications. So many things are there for this particular subject associated. See, in one of my client case, same bank from 1988, they have borrowed only working capital limits, no term loan is there. From 1988 to till date, in between total 77 times they have modified this particular working capital limit. That consultant to the bank, because at that particular renewal never used to come to me as a consultant, and it never used to come to even our secretarial team there. So it used to directly be handled by the bank consultant, who is a charge expert, who is a company secretary, charge expert, and the banker and the company director signature. That's all. So they are taking extra left signatures and they used to file. Believe me, all 77 times they have created fresh charges. All 77 times.
So same charge, 77 time charges.
Yes,
Winter.
77. Each time that for 150 there is a one charge, 125 there is another charge. If you see, it runs on hundreds of crores, but bank balance sheet shows hardly 10 crores. The company's balance sheet is only 10 crores outstanding, whereas charge document shows hundreds of crores. So finally, we exited from that bank somewhere in 2000. I think, recently, 2017 or 18, we exited that bank. Banker has provided only one letter saying that charge is closed. Now tell me, 77 unclosed charges are continue to be there, and that consultant says that we have to file all 77 satisfactions, and the same letter banker also agreed to sign all 77 CSG4s. The situation or the gloriness of this particular transaction, you should see that consultant charged the company 3,000 per form into 77 forms.
So he has made his money.
Yeah. Okay, next.
Okay. If the lender
So I
company
think I
is
have answered this 125, 150 query.
if the lender company is no longer exist, then satisfaction charges, how to actually clear the charges to MCA? I think you
I
said
think we have
actually you
already
can
given
approach.
this answer. Yeah, 83, you have a process, you can explore into 83.
Yeah. There must be a provision for the equal responsibility of the lender and borrower to all the cases, creation and modification, and especially for the satisfaction, for responsibilities on lender in case of the satisfaction. No, that's what I
So it
said.
is a
Practical
suggestion.
difficulty is there.
Modify.
We discussed this.
We
So
cannot.
we
Next.
cannot modify the law. The law as it were condition, we have to adopt it.
Yeah.
See, what is that? It is the government says that is your responsibility to get your assets released. Why will banker will bother it about it? He will not.
If the
Yes, sir.
company,
Next.
if the company whose favor is actually created cannot be connected, how to file the form of satisfaction of the charges? I already answered this question actually.
Yeah.
Hypothecation of the hard loan is within the purview or not?
I think we have already answered this.
Yes,
The
sir.
car is
Yeah.
an asset.
Yeah.
Core is an asset. In fact, in one of my client case, we have created a charge, and we are trying to file it. So what has happened? There are different method of hypothecations, or rather, I can say, like hire purchase. Hire purchase things are different. I have one client. What has happened? They have entered a master facilities agreement with the one hypothecated. What is the type? hire purchase company. Okay, one hire purchase company, they have entered into the contract with them, and that particular company will buy the asset or car from the particular car maker, and they will extend the money to the car lender, and the vehicle will be registered in that hypothecation, hire purchase person name only, not in the company's name, and they will hold the security from the particular person who is taking the loan. They will ask him to say that this vehicle I am owning, I am creating charts in your way. Because in my case, we have allowed the employees to acquire the cars in that manner. So more than 200, 300 cars were acquired from the hypothecator. Okay, company is not in connection. Company is not there in the in between. Only the hypothecator and car maker in between, and the vehicle. What is that? Finance. This person is there. However, company has given one guarantee to the hypothecation hire purchase company that in the event the employee doesn't pay, I will ensure that his salary is credited to you. So this was the deal. Now we ask them, can we create a charge? That particular hire purchase company says, it is my own property. I will not, in my books, I should create, not in your books of the company. But I don't know, there is some longer hypothecation as per the accounting treatment. You are supposed to, because in this hypothecation and what is that called employee agreement, the car chopper is provided by the company, car diesel is vehicle fuel is provided by the company, and there is some system, I don't know. Car company is allowed to claim the depreciation in its books, though the car is not there in the name of company. Very, very complicated. We are booking all these things in the company books, but company is not, car is not in the company, and no hypothecation is filed. So charges are there. So in this particular case, you should see what kind of loan is taken. If the company, the car is there in the name of the company in the books of the RTA, then you don't have any option. You should certainly file the charge with the particular financer's name, in favor of the financer's name. Otherwise, it will be violation of section 77.
Okay.
I have the specific question. A modification of the existing charges is under process. This pertains to the mortgage of the land situated in the state of outside of the Maharashtra, and company and the insider titling charges are situated in Maharashtra. The mortgage was actually created in consecutive delivery of the deeds by equitable mortgage. There is no requirement of the registration of the charge with the SRO. The mortgage document, that is the MOE declaration, framed in the state outside the Maharashtra. Trustees issued the letter certifying the mortgage date of the creation, detail of the property, etc., and advising the charge with the ROC. This letter will be attached to the CH1 under head instrumental modifying
Mr.
the
Bala,
charges. Yeah.
It's complicated. It is, the connection is not to be, it's too long to be answered. It can be answered specifically by Tirupati.
No, I will give you the answer to this. See, we had a situation similar to this. See, as far as the assets are concerned, immovable properties are concerned, in general, particular state has the legislation how the rights over the immovable property and the property like transfer, transmission, or the mortgage, all those things should be taxed as per the particular state stamp acts. However, if the document is executed not related to the registrable document, like example, mortgage by way of registration is nothing but it should be registered in a concerned sub-register office, and there the stamp duty is to be payable. If the document is not in that nature, like hypothecation, and this can be created anywhere under the particular state or particular stamp duty, you can pay that particular state and you can create it, and you don't need to pay the stamp duty of the property where it is situated. I have same situation now. We are dealing with that one case. What has happened? The company registered office address, it is Hyderabad, and it has a property in Bangalore. That particular property was given as a deposit or title deeds to the loan taken from the bank at Hyderabad by the company situated in the Hyderabad only. And we have paid the stamp duty as per the Hyderabad Act. However, there was an opinion from the banker, since the property is situated in Karnataka, the stamp duty should be paid. When I approached the sub-registrar office in Karnataka, he told, have you created a document in my books? No, you are not created in my books. And am I required to register your document? No, I'm not required to register the document. Now, what is the why I should collect you stamp duty for a document which is not registered in my state? It was created in some other state. You have paid a stamp duty, that is valid. The sub-registrar told the same way, it is valid. You can create, you don't need to pay stamp duty because the property is situated in India. Because the document what you have created is not a registrable document, it doesn't come to me. Suppose if it is a registrable document executed somewhere else, and if it comes to my state for the registration, I will collect the balance stamp duty or even full stamp duty. That's what he says. So it goes based on each state, how the stamp act says. Especially for Maharashtra, they have a stamp duty instance for each and every instance. You execute somewhere else and bring to the Maharashtra, then you pay the stamp duty for difference. You execute the document, even the property situated outside Maharashtra, in the Maharashtra you are executing, they say stamp duty should be paid as per Maharashtra laws, not as per the other state. So in Maharashtra, it is very peculiar. I suggest you go through the exact wordings of this particular state and what kind of document you are executing, whether it is to be taken to the particular state where the property is situated. No need to take means then you pay the stamp duty as per Maharashtra loan, even the property is situated outside.
Right. Yeah.
Who is required to file the charge form in case of the loan taken by the wholly owned subsidiary company, but the security mortgage of the land and the corporate guarantee given by the holding company to the bank?
Now tell me, just now we read 77. The property, property of whom is secured. I told clearly when I was explaining about CSG1, it says clearly whether your property is given as encumbrance or not. It has no sense who has taken the loan. Now, in the given case, holding company property is given as a security for the loan taken by the only one subsidiary. And only one subsidiary, as per the question, has not given any of its property. It is only the holding company that has given. One is the mortgage, other one is the guarantee, corporate guarantee. For mortgage alone is considered to be an asset. So mortgage can be created an asset or property, whereas the corporate guarantee is not a charge on any asset. It is a head, invisible head of the company. It is not accounted either asset or counted as a property. So for corporate guarantee, you don't need to file any charge. However, you have to file for mortgage of land in the books of holding company. In the books of holding company, not in the books of the subsidiary company.
The assets on which a security is created belong to the holding company and it is going to the bank. And yeah, that's the same thing. Okay. A credit limit is actually guaranteed to the security of the equitable mortgage of the property of the company. Later, the credit limit is enhanced and the additional property is taken as a security. So we need to register the separate charge when the limit is actually enhanced or additional security or modification of the charge is to be filed. I think modification. That's what we talked about it. Where the charge creating documents are executed abroad or not in their local notary, is it notary necessary overseas or apostille?
Oversight, wherever the country, wherever it is executed according to apostille or that way consularization as per the state, a country you are following, under which it is treaty, you have to follow. The documents are brought here, then it get educated. And
yeah, most of the documents which are brought from overseas are actually done as a apostille. That's what it is done. Yeah.
country and notary and all
See,
that.
if you don't have the notary and apostolize on any document that comes for the sub-registrar for stamping, which is executed abroad, the sub-registrar is not ready to stamp. And you should also carry the postal cover also. The postal cover through which that particular document is delivered in India, because there is a 3 months time is there. Within 3 months, you are supposed to produce for the adjudication of stamp duty. So hypothecation, sorry, notary and apostolize is a mandatory. Otherwise, that particular sub-registrar is not doing. We have got a situation last month.
It is not
If the,
valid.
cha
Yeah, next.
if the charge is not created the first time, but after renewal, the charge of created with attachment of the document for charge, which was created first time, what is the legal validity of the such charge?
I think we have already answered that particular charge created by you becomes a kind of unsecured that particular period. Once you create or renew it and you file the form with the ROC, from that moment onwards, he will be considered secured creditor. So even liquidator also will be only that time vacuum is created between the first and second. That particular point of time, if there is any dispute, you will not be secured creditor.
What is the role of the NESL registration?
It is a NESL, it was expected moment they launched the IBC, Insolvency and Bankruptcy Code. NESL is one of the main pillars called information utility. Okay, so they thought initially to migrate the charges that are being filed with the MCA system to their system. Like you have a SARSAI in case of Securitization Act, there is a SARSAI website is there, and they want initially that they want to mandate not only filing with the ROC or either removing from the complete filings of ROC and file with one single source. However, that is not been mandated. So NESL is, if you want to file, you can file there also. It is allowed. There is no issue. So however, filing with ROC is a mandatory. Filing with the NESL, it is an optional. If you want to file, you can still file. You can get registered as a borrower and give the details, and it will be securing more in the terms of the lender. Lender rights are protected if you file NSD, NSCL. However, filing with ROC under 77 is a mandatory because you are a company.
Not filing beyond 120 days, if the loan be classified unsecured financial statement. I think we
have answered
spoke
this.
about this.
No, what they have got, it is asked
if a
in
bank
financial
manager,
statement, it will be shown as secured in financial statement.
If you, madam, if you read the subsection 3 of 77, where this particular, classification or the rather, against the other creditor, against the liquidator only is there. There is no duty on the company to reclassify that as unsecured. Nowhere is written. No financial, including schedule 3. You don't have any such clarification linking non-filing. However, there is one regulatory note you are supposed to mention saying that this particular charge was created against this. When you are describing your asset, when you are describing particular loan, there you are continue to describe as a secured, unsecured. It doesn't say anywhere it's a secured, unsecured.
Right. Yeah, next.
If a bank manager refuses to digitally sign the charge form in case of the car loan given by the bank, then how can company charge from unilaterally without the bank manager's DSC?
So ROC, they will talk, they will send the notice, and then they will compel. That way we can. Yeah, next.
You can write to the bank and ROC one common letter.
And then ROC will write them from their office.
Correct.
What is flexible to fixed? Explain the meaning.
I think it was explained already, no?
Yeah,
See,
already,
flexible to fix is like you have a stock. Okay, stock is allowed to be used by the company. Suppose you failed in prepayment. What is there in the godown, that becomes fixed. Now the banker will seize that. Now you can't use it. It becomes a fixed there. However, during the course of the loan and there is a repayment, no repayment default, that a stock can be used. Continue to. So it will become a floating charge. Once you default it and charge is lying in the godown and banker will come and close it. Put his seal, lock and all, then it is a fixed. It becomes fixed. He cannot go beyond that. Something like that.
Certification of the charge or modification of the charge straight process If charge is actually filed within 30 days, it still be straight process approved by the registration of the charges. Please advise.
No, I think this is a 100 till 120 days. It is only STP route only, including charge satisfaction. So you will get a certificate immediately, like any other form in STP.
We are an unlisted public limited company, family owned. Land is owned by the promoter director and the building was actually constructed by the company. How to actually cover these under CHE1? In case of the vertical split of the family and the main promoter is head of the family departs, how the handle this case? This is what somebody is asking.
So it is simple, sir. You go with the joint ventures, JVs. No, land will be in the name of the owner, and then JV partner is the company. Now, as per the JV agreement, company also gets a right over the land and developed property. Okay. Now, when you borrow the money, the landlord would have given his power of attorney also. Now you file a form wherein you will clearly mention your share in the land also while filing the charge form. Though you are not created any charge mortgage over there, you will be mentioning because the property is not registered in your name, but you have a right to over the property tomorrow if you develop. Similarly, here the land is belonging to the particular individual, building is constructed. Now you need to understand whether landlord has given property to you like a JV, why the building is constructed, it must be a lease land. If it is a lease land, during the lease period, the company can construct the building and you are owner of the building and you can create a charge over that building, but not you cannot create a charge on the land, whatever it is. It is not your property. How you will create a you may create leasehold rights, charge over the leasehold right for like 30 years land is given. So over that leasehold right, you can create a charge without knowledge, without consent of the landlord. So you have to see the transaction, how the transaction is there. It goes based on the facts of the each case. They say there is a split and all. Split and all, okay, means instead of earlier one owner is there, now you have two owners or three owners. So they are continue to own their land, you are continue to own your building. And you can create charge only on building, which is your in balance sheet, you are the owner. So you can create a charge on the split also.
If charge is not created within 120 days, after 120 days, can the company go to NCLT and
No.
create charge? No, you cannot do that.
Go to NCLT.
What is the case of the company wanted to complete the process of the charge satisfaction and the lender has sold his portfolio?
Same thing, actually, you have to connect to the ROC, discuss, because these all are practical thing, you have to work it out.
No, in this case, I think you have given a security of your land to particular loan. Meantime, you sold that land. But can you sell the land without knowledge of the banker whom you have given as security? So without his NOC, you cannot sell the land. Once you had given NOC means he has taken away that from the entire assets. That land is no more as a party to the secured assets. So you have to file there is a modification. Suppose this is the only land, then you have to file a satisfaction over there. Then you can file this. See, no satisfaction means no one will buy your land, showing as a security in the books.
Can CS won't be filed in the registration after 127 any manner if there is any continuation of the process available and the form is there? This I think we discussed actually.
Yeah.
Can we file the CHV4 without signature of the banker?
I think that I was told technically it is possible, but we are not able to file.
The practical difficulty.
Practical difficulty is there. You need to check with the concerned office, but as per as the form is concerned, you will not be able to fill the form without the banker's credentials like PAN number, all those things. You can't fill it. You have to download from V3. After that, only signature will come.
What is the situation after the expiry of 120 days creation of charge? I think we discussed this.
Explain this, sir.
CH8 matter very nicely explained by Mr. Tripal.
Thanks to
The kind expectation one can expect this be okay. If a company is actually taking fund-based and non-fund-based facilities against the charge on the movable assets, on the stock, and the same is actually exceeding the paid-up capital, free reserve, and the securities premium, intending to create the floating charges, whether it need to seek approval under Section 181A and Section 181C through the special resolution from the shareholder. This
Yeah, see,
question
look at
is
that. You can see when in a public limited company creating a charge on the assets as per this 180, they have given 25% of the value of the asset of the company or 25% revenue, that is revenue earning asset that you are creating a charge. Then you need to have a shareholders approval under this particular section. At the same time, suppose you are giving a guarantee or a security of your asset to someone else, then you need to even comply with section 186 as well. Apart from that, 77, 180, 186, and there is be a board resolution. These are required. Here they are talking about only limits. So limits that immovable property, you have to see that if the facts, the 25% above you are going to cross that limit undertaking, the given undertaking, it is explained as a two baskets. One is the 25% of the asset of the company or 25% revenue generating asset you are giving. If it falls into the basket, then certainly you should have the shareholders approval. Board has no power to do.
Karthik Varadarajan is expressing his thanks to you for explaining the section 83. We have the unique case. The company master
Very
says
long
source.
thing. Basically, it says that same thing that, the charge was created and then it was satisfied but not registered. Then the company changed the hand twice. Now they are not open, give NOC. Same thing is there actually.
Yeah, he explained this actually. This sort of the cases he has
You
explained
can
actually.
approach one aspect with all these data. You can approach the concern ROC to
Right.
invoke the 83. Yeah.
Because
Kindly provide the email ID and the contact number of Mr. Tirupal, please. Somebody is requesting.
down, Tirupal.
Though I have not seen this so far, can we file CHE4 for partial repayment?
No, we can't. See, CH4 is for final good settlement. You have to file modification for partial satisfaction, not the CH4.
It is a good idea to release the questionnaire, but I would request you to do it at the
Okay.
end of the week.
Okay.
Yeah, that is okay. Okay. Can you let me know any any empanelment of the CS in getting search reports work from banks? But now the charge for the filings, no, that you'll have to do it. Who can actually say all this?
No, there is no
Yeah.
empanelment. You have to approach the bank and you
Yeah.
show your expertise, and they may take your
Correct.
service.
And as regards in between questionnaire, it is just to check that, people are attentive. That's the only thing. And if after 10 minutes people are already hungry when we are doing, people start leaving. So that's why at the end of the session, if after 10 minutes, even 2 minutes, people will not send. But point noted that we'll take care. Okay. Next.
Nowadays, most community are operating at that date. So creating the charges becomes very important part of the corporate governance. As practicing secretaries, could you highlight some of the areas, the difficulties, and streamlining this area of the work?
I think we have discussed. Yeah. Please. Yeah.
We hold the primary responsibility to file the charges with ROC, the company who has actually availed the loan and bank. Yeah, that is already the opinion he is giving. Two most problematic areas of the charge is registration as a charge in which finance is creation of the lien and the fixed deposit, because the charge holder are not interested in non-cooperative and vehicle charges already registered with the RTO, and lien FD is with the only. If there is any practical solution for this default due to non-cooperation of the charge holders?
See, we need to tell and inform the charge holder, because you are not dealing with an individual and you are not dealing with a kind of a partnership form. Whereas you are dealing with an animal called corporate. This is an animal registered with the concerned registry. And this animal behavior should be reported from time to time. And if I don't report to the particular officer, and you will be the loser, not me. I may be penalized for not reporting, but you will be the loser. Ultimately, the animal which is being allowed to be roam in the city, its assets should be, encumbrance should be informed to that particular office. It is a regulatory requirement. That's what the MCA expects you. And if you don't want to, or the charge holder doesn't want to file this thing, then he is the loser, not the company. You can write it very clearly.
Right. Yeah.
If the loan is taken from the bank against the fixed deposit,
Yeah,
whether
that's
this
Fixed
we have talked
deposit.
about it. Yeah. ROC asking valuation report when we are actually filing the charge creation CHV 9 secured debenture. Why?
See, if you look at the depository rule, in the deposit rule, one of the paras it says 21C, one of the paras it says clearly NCD. If it is secured, then it is exempted. If it is secured, they are given clearly based on the tangible assets that are available in the balance sheet, and the value should not be less than this. And there they are given clearly as per the registered valuer. Whenever company is issuing NCD, and you need to file the charge. So they are going to that rule, asking the charge you have created for the security of that particular debenture, whether that is properly secured, whether the assets been as per they are given, it must be over and above the value of the loan, and charge that particular document, whatever it is, certifying that it is over and above, should be certified by a registered valuer. That is the reason they are asking. It is as per deposit rule, not under the 77.
As an auditor, what document need to be checked in relation to the charger to see the company has not violated?
See, as an auditor, you have to check whether first you see the balance sheet. Are there any borrowings? Next thing is, if the borrowings are there, are they secured or not? If they are secured, have the company pass necessary resolution either from the board and shareholders. And if they pass the resolution, have they informed with the ROC in filing the necessary form like CSG1, CSG9. At least this extent you should see. Next thing, suppose they have not filed the form, though they have created charge with sub-registrar or RTA. Have you filed? Have you reported the same for non-filing more than 120 days and the regulatory matter in the balance sheet? This is about the previous year. When you are doing an audit, 365 days, there would have been a balance sheet of the previous year, whether there is a non-compliance. That also you have to examine. And see whether there is a charge register of charges is maintained or not. These are the broadly you can verify and see that whether it is clearly covered or not. Then only you can comment on it. If not, then you have to comment. The charge was created, not filed. Charge created but not registered. Charge created but not maintained in the register. Charge created, not filed, but however, in the financial statements, in the explanatory statement, in the notes, they are not reported. These things you can add it.
Most banks, including SBI, have a document called take delivery letter, which accompanies the physical deposit of the title deeds. Further, the mortgage of the hypothecation document also witnesses the handing over of the title deeds. So, in actual practice, these two actions are simultaneous.
Yeah, very good.
Okay, then Form CG1 is, however, discontinued.
That I don't know. CG1 cannot be discontinued. Reason is that CG1 is meant for other sections also. It's not only for charge related documents. So we have to check that. Suppose example I will give you. You go to the Schedule 5, Part 1. If there is a non-resident and he wants to be a managing director of a company, so the 12 months and all he was not a resident, he has to approach to the central government. So CG1 cannot be removed at any cost. It may be due to technical reason they are not able to develop it. I don't know. So it cannot be removed at any cost.
In case the title deeds are not actually returned after the repayment of the loans, the auditors took a filing of the document with the MC evidence withdrawn. Okay. Please share the PowerPoint presentation. We have been telling you actually PowerPoint presentation is not actually shared. In fact, our webinar, actually recorded webinar is disseminated. You can actually watch it, which is actually available in the YouTube. For working capital loan, cash and credit account, the charge creation required. If yes, what amount? Because outstanding amount is fluctuating.
The technical working capital limit, you have to create a charge on the sanction amount. not on the money that is being fluctuating day in day out, because the amount is dynamic. Moment you put one check, the money will come down. It is a OD, overseas, what is the overdraft facility. So put some checks, then it will come down. So that is, we are not filing a charge for the outstanding amount, whereas we are filing for the sanction limit. In our case, I told 22 crore charge sanction was there. We filed for 22 crores, even though we are not done even single paisa.
In case of the company given the guarantee repayment of the car loan,
It's not a question. They are telling that if company cannot claim depreciation, we discuss, no, when the car is not.
That the accounting treatment, I don't know. And
Yeah.
big four auditors there, think of it. They are allowing depreciation, everything.
Yeah, next.
yeah, in fact, most companies, they take the leased car, the depreciation is actually availed by the company, but though this is hypothecated to them, that is what I also seen in my practice.
Now, hypothecation should have been done. That was why I'm insisting. I'm a secretarial auditor there. They are not ready to, create charge. And it was clearly mentioned they are secured assets in favor of the so on, like that.
Some banks are insisting charges to be created for the corporate guarantees issued.
Now ask him where it will fall. Some banks have no sense. Now where it will fall? Will it fall in an asset or property?
What about the assets stolen or lost should be filed the satisfaction of charge?
No, asset stolen, that is your responsibility to replace. No, charge is not gone. No, that loan is continued to be there. Asset is gone.
Yeah, next.
You have to
We are-
file a modification. You have to
If
file
we
a
are-
modification technically. If there is no asset, you have to file a modification.
If you have to file when the time frame counted 30 days from the filing of the FIR or from the date of the no, that you answered actually. Because loan
It
is
is
actually
technically notice when you have noticed and when you brought this knowledge to the charge holder, and charge holder also you would have visited. So from some confirmation is needed. You take some that date or FIR, you say you are filing FIR, that date also can be considered.
Is there any renewal for charge creation? I don't know what is this technical new word. I only know charge creation,
renewal?
modification, and satisfaction.
Guarantee extension.
Are they talking about working capital renewals?
Corporate guarantee extended by the holding company and subsidiary company in modification from the required. How can actually derive the ad valorem value?
So first of all, we told corporate guarantee is not a registrable charge. There is no requirement to file any form here. And ad valorem is basically amount. Any corporate guarantee, there is a connection with how much loan you have taken. So over that money or any charge that you create, there is a charge amount. So over that, they will calculate the ad valorem, not on the value of the asset that you are giving.
30 days counted for the bank releasing the asset after the repayment of the loan or getting the alternate security. How the bank actually secured when asset. I think you discuss actually not only that, the various charges, etc. Another thing you said actually. How can I actually change
Charge pattern. And what documents to be attached.
What document to be attached?
So it's a typical thing we have to discuss because again a patent is there that the charge document that bank insists the document. So first you have to deal with the bank, what document they insist, and then what is the security creation charge document that is to be attached. Pirupal, you can add what you want to add.
That's correct. So you need to find out what is the charge pattern first, what is the document, you need to focus on that.
Yeah.
There are 3 documents executed with the bank for the loan purposes. The hypothecation date is 5/8/25. MOD property is one document. 7/8 another MOD immovable property a separate document on 8/8. Is it possible to file the single form of all the 3 separate forms? How should I actually change
you have to file 3 forms, one after other. First form should be filed. Of course, fortunately now, the moment you file, it will get registered under STP, and it will allow you to file second form immediately. Again, it will allow to. Earlier, ours used to take a lot of time to register the first document. Meantime, the due date to file the second form also used to go. So now we are fortunate because of the system, STP route. Moment you file the form, it will get registered. So 3 forms should be filed. First form as a creation, all 2 forms, next 2 forms are modifications.
Who is required to file the charge form in case of the loan taken by the wholly owned subsidiary company, but the securities of flat? This I think you answered already. Yeah. Non-filing of the charges against the vehicle loan, are they required to be flagged in the secretarial audit report?
It is not only at secretarial audit, they themselves should flag it in the balance sheet level at regulatory compliance. There also they should level. No, they should flag.
I think the disclosure requirement is actually required, isn't it?
Yeah.
The
There is a requirement.
financial notes of financial statement. Yeah.
Yeah, I
actually,
told no schedule other
Yeah.
regulatory. I think
Jai-
para number it is
Jai,
there
also
12 or
in the
something.
presentation, it was there. If you are
Yes,
delayed
it is
or
there.
filed,
Correct.
yeah.
then you have to disclose that reason for the delay. It is there.
Correct.
It was
Yeah.
there in PPT.
Yeah.
Under schedule 3 para number L. In the L you have para number what is that called satisfaction, no? So there is a para number 9 or 12 is there. So there you have to fill.
Who is required to file the charge form in case of the loan taken by the wholly owned subsidiary company?
Again,
And
the same thing,
same question. I
I
think
did
that's
that.
all. I am done with all the questions.
Sir.
Now, if anybody has raised their hands, then we can talk to them.
Correct.
I don't see any
Don't
hands actually
we
risen
discussed
here.
in depth. Tirupal has
Yeah.
explained very well everything. And we attended the-
Karthik Varadarajan has risen the hand. Karthik Varadarajan,
Yeah.
you want to talk something? Karthik Varadarajan hand is risen.
and Prasanjit Goa.
Person says Goha, his hand is also written. Yeah.
IT just allow them to speak.
Yeah. You can unmute, you can speak. Yeah. Karthik, you are there? That other gentleman, Goa. Yeah. Yes, Prasjit Goha.
Am I audible now? I'm Karthik here.
Yeah, yes, please.
Ah.
Very much.
Yeah, I just wanted to supplement a couple of things which Tripal very rightly said. Just wanted to supplement. In the case of fixed deposits, he explained, the requirement of Companies Act 1956, which laid down some 7 or 8 or 9 kind of charges that can be registered. And the new act has gone on a different method of creating charge. See, this is also because under the old act at that time technology was not so technology was not adopted by the banks, so they were giving only the physical fixed deposits, which if we have to pledge, we had to place it with the bank. So there was no question of any second charge or second misuse of fixed deposit. So that scenario has changed now, due to which people are now getting their fixed deposit in the electronic format, and we don't know who has the control over it. So that is also one of the reasons why against fixed deposit charges should be created. I'm just supplementing what Tripal had said.
Thank you.
Yeah, the second observation I had was, when we exhaust the 120 days, this one in 120 days after creation, somebody had asked what is the probable solution, and Tripal had responded saying that we may have to create a second time, we have to create the document with reference of the first time and all, paying stamp duty, etc. All that is fine. The only challenge what I observe, of course there is no other way out also, we have to live with this challenge. The only challenge that I observe is that the bank would be questioned by their auditors as to what were you doing for 120 days, why were you sleeping over it? Okay, so that becomes a red flag for the bank. However, there is no other way. This has to be done this way only. This is my second observation. The third observation, why I had only raised this question of partial satisfaction, is that the form itself is asking for what is the amount that you are satisfying. Now, if it is understood that it has to be satisfied in full, then I think they should not have given that column for amount to be satisfied. System should automatically take and it should be over. So it was just a thought, that's all. Not that I am concluding this way or that way, just a food for thought, that's all. Thank you everyone, and Tripal has explained some of these concepts very excellently as usual, and Mehta for doing this thing week after week. Bala sir and Sudhakar sir and all of you are doing excellent job. I wanted to acknowledge that. Thank you so much.
Thank you, sir.
Thank you so much.
Thank you.
Thank you, Karthik. Karthik, so much.
Thank you, sir.
Yes. Prasanjit, go ahead.
Yes, sir. Bala Sahab and the full Mehta team and our speaker today, Mr. Dhrupal, thank you very much for this lucid. I had raised a question, sir. Maybe I would have missed. Pardon me for that. There were 2 points. One was on the straight process after the, the initial period of 30 days, which you answered. The other one was between longish query. It's a case where a company and the lender, they are creating or rather modifying a charge for a situs of a property which is located outside the state, and the stamp duty has been done in that particular state, where of course the stamp duty is much softer, whereas this company which we are talking about and the lender, they are in Maharashtra. So while filing the CHG1 for modification, the respective column where we have to mention the instrument modifying the charge, the trustee, just to avoid that document to come again into the state of Maharashtra, which has a very high, ad valorem duty, sir. Mr. Tirupal also mentioned about the obnoxious high duties, stamp duty cases. So the trustee has given a very detailed letter certifying that when the modification of the charge was created, it was through constructive delivery of equitable mortgage. Number 2, the details of the property is attached.
I think, Mr. Prasanjit, can I mention this is a very personal, you can directly connect with Mr. Tirupal. Yeah, this is not possible to handle this way. So I humbly request, please. Okay.
Thank you.
Thank you. Thank you, everyone. Thanks for your participation. Thanks. See you next Saturday. Bye. Thank you, Tirupal.
Thank you,
Jay.
madam. Thank you to all. Thank you.
Tirupal,
Bye.
Tirupal, hats up to you. In fact, today our
Thank you, sir.
presentation was lesser, but the question answer session was a long one. You were able to share a lot of your experiences. We have gained a lot of things actually. Although I am an old-timer company secretary in 1956, there are a lot of things have changed. Even the practical situation has changed. I experienced only few practical situations, but now the experience in which you have a lot of things, it is really, adding the knowledge. Definitely, our participants also benefited to the greater extent. I really look forward to you in more sessions. You are actually our frequently visiting panel to us. Thanks a lot.
Thank you, sir.
Thank you.
Thank you.
Thank you, madam. Thank you to all. Thank you. Bye. Jai.
Thank you.